we talk about that, Mr. Bursch, the difference between a benefit and a right? I mean, I assume from your answer to Justice Sotomayor that you agree that the state has an obligation here. Is that correct?
To provide benefits on the plan, but significantly,
the state has an obligation to provide this particular thing, right, which is the state has an obligation to ensure that a person, I don't even know how to say this without saying right, has a right to choose their doctor. That's what this provision is. It's impossible to even say the thing without using the word right. Has a benefit to choose their doctor? The state has to ensure that individuals have a benefit to choose their doctor? The state has to ensure that individuals have a right to choose their doctor. That's what this provision is.
Well, the language that you're focused on, may obtain, is not clear rights creating language for 4 reasons.
I don't want 4 reasons. I want you to answer my question. The obligation is to ensure that individuals can choose their doctor. And when we speak of that, the obligation is to, I mean, there's a correlative right. There's an obligation, there's a right. And the right is the right to choose your doctor.
Justice Kagan, I won't go through my list. There's many reasons why that analysis is wrong. But simply because we understand colloquially that something might be a right doesn't mean that Congress has put a state on clear notice that it could be sued in federal court under 1983 and subjected to liability and attorney fee shifting if it doesn't follow that provision, particularly in a substantial compliance regime.
Well, here's what the state knows. The state knows it has an obligation. The state knows that that obligation runs to individuals and that individuals are specifically discussed in the statute. And the state knows the content of that obligation, which is that every individual has a right to choose their doctor. So what doesn't the state know that's important here?
Whether it's going to be sued in federal court.
Well,
that word,
if you know that you have an obligation and you know that the individual has a right to choose their doctor, that suggests that there's some kind of enforcement.
Gonzaga makes clear that there's a difference between a duty to provide a benefit and a right that subjects you to 1983 liability. We would expect a provision like this to use individual because, of course, a doctor treats an individual, but the word individual can't be rights creating. It appears more than 400 times just in 1396A. That's hardly atypical.
One of the benefits provided by the Act is that you may choose your own doctor. If a person thinks that's not being provided, what remedies do they have?
They have a very specific remedy if they are denied benefits. There's an administrative appeal process that they can go through. But there is a separate remedy for providers who are disqualified. They also have an administrative appeal that could go through the state court system and that could come to this court if necessary. And it makes sense that Congress would create the appeal right for the disqualification in the provider, not the beneficiary.
I'm sorry. The Medicaid recipient can only sue a denial for services that were actually rendered.
Yes.
If a doctor can't render them, then they can't sue under that.
That's correct.
And the requirement of an administrative review process is not actually required by the Act. It is something that a state can choose to give, and they can choose its limits. Here, they can only challenge, providers can only challenge a certain subset of disqualifications via South Carolina's administrative review process. They can only challenge a disqualification because of a criminal conviction or abuse. So the providers here did go through the administrative process, and they were told they can't sue for this here.
Justice Sotomayor, that is what they put in their brief. That is absolutely not what that regulation says. 126.404 says that those particular things that you mentioned, like a criminal conviction or recouping
So
payments,
why were they denied here?
well, can I finish?
They're not, but go ahead.
Yeah, so first of all, those things that you mentioned, that gives them advance review before consequences take place. But the regulations make absolutely clear that they could raise anything that they wanted in their administrative appeal. And the reality is they haven't pursued their administrative appeal yet. They went straight to court, they recruited a beneficiary, they filed their 1983 suit. The state responded to that with a brief in opposition to preliminary injunction motion and said, hey, your remedy, which you agreed in your contract was your exclusive remedy, is to go through the administrative appeal that we offer.